think, Jennifer? We're going to start the workshop portion of our meeting. And we thought, since the beginning of the new year, that we do just a quick refresh on our rules of procedure. I can't remember the last time we reviewed them, but I think it makes sense just to, like I said, start of the new year, to reset, kind of go over what we drafted. We drafted these maybe 5 years ago?
Yeah, so the last revision date on your rules of procedure was January of 2018. So my guess is that's probably the last time that we've reviewed these. So yeah, you're right. Good refresher. The City of Beacon Planning Board has its own rules of procedure. These are regulations that are not codified in your code, but just like they're aptly named rules that govern your procedures for how you conduct meetings, expectations of the membership, voting requirements, things of that nature. So I did email a copy of the most recent rules of procedure to everyone earlier today. Hopefully you have that in your emails and can follow along. So I figured we'd go through a summary of what your rules of procedure currently say, and as we're going through this, if you think of something that should be amended or modified based on your current practices, if they've changed over the past however many years, what is that, 3 years since we've last reviewed these, or anything else that you think should be addressed based on your experiences over the last couple of years, then by all means chime in, interrupt, and we can talk about it. All right, so your current rules of procedure start out with specifying that the planning board holds its meetings on the second Tuesday of every month at 7:30 p.m., which is immediately preceded by a training session at 7 o'clock. The meetings are held here in the Municipal Center at One Municipal Plaza, and that's unless otherwise posted or noticed. So, there are exceptions when there's a legal holiday on a Tuesday or for any other reason why we need to shift the regular meeting date.
Pandemic would be one of those.
A pandemic, exactly, why they might not always be located here. Sometimes we're virtual, but that is when your regular meetings are held. The second bullet point here is membership expectations. So this is where we list what's expected of the planning board members. You're expected to attend all duly noticed meetings of the planning board. Attendance at planning board meetings is critical for continuity of review of the applications, and also in fairness to the applicants. When they have less than a full membership of the board, they still need 4 votes in order to have something passed. So it helps the applicants to get have the full constituency of the board, so they have a full, the benefit of the full opinion of all the board members. Members have to notify the planning board secretary, Ms. Etha Grogan, and the planning board chair if you do expect to be absent as soon as practicable. You're also expected to be familiar with all of the materials that are submitted to the planning board in connection with each of the applications. So all the materials submitted by the applicant, as well as the comment memos from your consultants and staff, anything that's submitted to you. Expected to be familiar with that. You're expected to complete your training that's required by law. So several years ago, the New York State Legislature imposed training requirements on planning board members and zoning board members. And that's 4 hours per year. Training is available through organizations like the Dutchess County Planning Federation. Westchester County Planning Federation has programs as well. New York Planning Federation. There's a lot of organizations, both in the region and statewide, that offer really, really cool programs specifically related to planning and zoning. You guys are lucky because we have these half-hour sessions before each meeting. So the intent for these sessions is that this is providing you with training in compliance with that 4-hour requirement. So we receive updates from John Clark on planning-related items like lighting standards, parking issues in the city. Periodically, I'll provide training on SECRA requirements, your jurisdiction. What does it mean if one of your decisions gets challenged in court? Those half-hour sessions over the course of the year help to provide your training requirements.
Just curious, how is that reported? Because I know the city's very good about reminding us that we need training and offering links to training resources. But knowing this, this obviously covers our training sessions. Or
Yep.
half hours, this covers our training requirement. That's recorded by the city and
It's kept track of by the city, and it does play into your eligibility to be renewed as a planning board member. The city council could, if you were to miss all of your training requirements, that's something that the city council could take into consideration when your appointment comes up again. So. And then lastly, you're expected to be familiar with the applicable provisions in the City of Beacon Code. So everything from the architectural design chapters to zoning to stormwater management, subdivision chapter. There's various chapters within the City of Beacon Code that relate to the work that you do. Obviously, you don't need to be familiar, word and verse with all of these provisions. I certainly am not. I have to check it every once in a while as well. But certainly to be aware that there are these various chapters with requirements that apply to many of the applications that come before you. And I should also mention, too, the comprehensive plan is a very important document in the work that you do as well. And it's important to be familiar with that document as well. And many of you were involved in the formation of that document. Moving on, the rules of procedure list the responsibilities of the chairperson. Chairperson is the executive officer of the planning board and is designated by the mayor. So the mayor has the authority under the city code to choose who's going to be the chairperson of the board. The chairperson has the responsibilities and authority designated by law in both the City of Beacon Code and the general city law of New York State. The chairperson is expected to preside at all meetings and hearings of the planning board, is responsible for signing final site plans and final subdivision plats. So in your resolutions, you know that you have various conditions that need to be satisfied by the applicant prior to the chairperson signing the final site plan and signing the final subdivision plat. So after you are done with the application, after the resolution is approved, it goes through another whole series of review by your consultants, where the applicant submits revisions to the site plan to meet the outstanding comments in the city planner's memo, the city traffic engineer's memo, or the city engineer's memo, whatever the case may be. Once each of those consultants has signed off and said all of my comments have been satisfied, that's when the chair will finally sign that subdivision plat or site plan. And the chairperson is generally responsible for performing any other duties that may from time to time be required, in addition to calling special meetings of the planning board. If something comes up in between regular meetings that requires attention, the chair has the authority to call that special meeting. All right, guidelines for planning board members.
Just on that hasn't happened as long as I've been chair. And
a special meeting, yeah.
I can't remember a time when I was serving on the board as a regular member that it happened. I mean, there are executive sessions. Does that classify as a special meeting? No.
An executive, it can be a special meeting is something that wouldn't be held on the second Tuesday of the month.
Right.
So
what would rise to, I'm just curious, what would rise to the level of a special meeting?
There are various things, like, for example, if an applicant, for whatever reason, is under a particular time constraint and needs to have an action from the planning board because of some outward force, whether it be obligations in a contract of sale or something, that they need an action by the planning board, you have the discretion to call a special meeting to consider that. I had another board that I represent, they had a special meeting recently to consider whether they were going to continue holding in-person meetings in January, or whether they were going to transition over to be fully virtual because of the rising numbers these days. So it's things like that. You can call a special meeting to discuss administrative matters of the board as well. A couple of examples.
Any ideas on special meetings, guys?
I've seen it actually happen when the planning board agenda is too long,
Yeah.
and the board says, okay, it's midnight, we'll carry over, and they'll set a special meeting.
I didn't know we had that as a lever, although it just extends the pain.
Yeah. Yeah, it's easy to get it done, but yeah, the applicant's there, he's on the agenda, and now he's got to wait another month, and that could impact him moving forward.
Yeah.
Yeah, good to know.
It's only difficult when it's public hearings,
Yeah,
notifications.
Right.
yeah, it does start to mess with the timing a little bit. Okay,
Yeah.
interesting.
All right, so the next section is guidelines for planning board members. Your rules state that a planning board member must be recognized by the chairman before speaking or making a motion. And a member shall address the chair and shall wait
Excellency?
to be recognized.
His
Right.
Excellency,
I hope
yeah.
you wore your ring. So your ring could be kissed as well.
So wait a minute, say that part again? No.
The part about the ring, or?
No, I just didn't know.
Suggestions.
Right, so your rules say that a planning board member must be recognized by the presiding officer, the chairperson, before speaking and or making a motion. So, in other words, a board member can't just blurt out whatever their comment is. They have to ask permission. May I be recognized?
New year, new rule.
So yeah, a member shall address the chair and wait to be recognized. So that's in there for what it's worth. Conflicts of interest. If you have a conflict of interest, you are prevented from participating in a matter. You should immediately inform the chairperson and the planning board secretary and the planning board attorney of that conflict. You should not be receiving materials on that matter. You should leave the planning board table and ideally leave the room, or at least sit in the back of the room. And you can't vote on the matter or otherwise participate in the discussions on the matter if you have a conflict of interest and you're recused.
Yeah, this is an interesting one, because there have been obviously times when there are conflicts of interest, and those are clear. There are times when you might have a question.
Yes.
Feel free to.
And when there
bring
is a
your
question,
concerns to
absolutely,
Jennifer
reach
Gallo.
out to me. You all have my email, my phone number. Reach out to me, and we can talk it through. Because most times, I would say, they're not clear.
Yeah.
Most times, it is a little bit of a gray area. So,
I just had one recently where I thought there might be a concern, and we had a big discussion about it. Obviously, it wasn't, but
yeah,
it's good just to know.
Absolutely, absolutely. And we can talk it through, but ultimately, the answer may be to consult with the Board of Ethics. Have the Board of Ethics issue an opinion on whether there is in fact a conflict or not. And then you have something that you can really rely on.
Do we have a Board of Ethics?
Yes. Every
Never met
municipality has. Well, that's a good thing. And I'll mention too, Chapter 29 of the code is the city's ethics code. So that's what you should look to when you're thinking about conflicts of interest.
Can I just?
Yeah.
Can I be recognized?
Your Excellency.
Yeah. Oh, you don't have to call me that. Where is the city code? I couldn't find it on the website.
Sure. So I'm not actually sure where it is on the website, but if you Google City of Beacon, New York code, you'll come up with a link for e-codes. E-code is General Code Publishing. That's their website. That's the codification company that all the municipalities use.
Send you a link.
There you go.
Okay.
Even better.
I think it might be under the building department,
The link?
the link.
Yeah.
The building department, yeah.
It doesn't show up when you just do a search on the website. On the
Okay.
city website.
Next section is non-disclosure of confidential information. If in the course of reviewing an application or discussions with city consultants, you are the recipient of confidential information, this is just a reminder that you cannot share that confidential information that you've acquired through your position on the planning board, or otherwise use that information for personal gain. Kind of a no-brainer, but something that I guess needs to be stated.
Usually if it's something is discussed in a public forum, it's not in the realm of confidential. So,
Right, but there are conversations that perhaps a board member may have with me, or a board member may have with one of the consultants,
I see.
that may be confidential information that shouldn't be.
Yeah, okay, so it's just something to be really conscious of.
Yeah, I think it's very rare.
And I was going to say, it's not often that that's come up.
Absolutely, absolutely. Okay, next section is meetings. Generally, all meetings of the planning board must comply with the open meetings law. The exception to this is attorney-client privileged communications. So we can have a full quorum of the planning board in a meeting, either on a conference call, a Zoom call, in person, with your attorney, with me, for the purposes of attorney-client privileged communication. That is not subject to the open meetings law. It does not need to be noticed. That's an exception to the open meetings law. So it's not necessarily an executive session. It's one of those exceptions in the statute. You're entitled to privileged and confidential legal advice.
So anytime the members of the planning board get together, it's considered.
Use the microphone.
Anytime the planning board members get together, it's considered a meeting?
Yes, if there's a quorum of the planning board members present, so 4 or more of you, and you're discussing business, that is a meeting of the planning board that has to be publicly noticed. If it's not, you're in violation of the open meetings law.
So if we wanted to have a picnic together, we just would need to make sure that we didn't talk about anything planned.
Don't talk shop. And there's also, there's the appearance too. You want to try to avoid that. I mean, if you happen to all be together at the supermarket or all together at a picnic, and are seen talking to each other, unless you're talking business, that's not a violation of the open meetings law. But I think,
It's okay. I ignore
it's
these
important to
things
be
when I see
aware
them
of the
anyway.
perception of that as well.
Yeah, okay, that's helpful.
Let's see. Site visits. Site visits may be conducted by the board either as a group, or you can do site visits individually. The important thing about site visits is that they are for the purpose of gathering information and observing. It's not for the purpose of having substantive discussions amongst the board members about the application. You can ask questions of the property owner or the consultant that may be there, but it's really not a time to deliberate and discuss. That's what you should do when you come back at your next meeting, have those substantive discussions here in public, because again, it's a gathering of a quorum or more of the board, and it's subject to the open meetings law if you're talking business.
And there have been questions in the past about when we've done group site visits, how to conduct ourselves.
Right.
And that was obviously the key point, that we're not there to discuss the application in any substantive way, or
Right.
deliberate, or otherwise make decisions, right? It's more purely information gathering.
Exactly. And members of the public are not allowed to participate in site visits unless it's on public property or unless the property owner invites the public, because at the end of the day, it's private property. And the applicant has rights to exclude members of the public on their property. We have a couple minutes left here. The next section is proceedings. The chair shall preside at all meetings of the planning board. In the chair's absence, the acting chair shall preside. The acting chair is designated by the mayor. If the mayor hasn't designated an acting chair, then the chairperson gets to designate somebody. Typically, you have a history of designating Randall.
Yes.
Yeah.
Although I've had instances where I've wondered to myself, who, if Randall can't attend,
Yep.
we should look to.
Yeah, then you would have the authority as chair to designate somebody else.
So just,
But it's in your discretion.
yeah, maybe outside this meeting we'll have that conversation.
Sure. Under New York State law, when you have a public hearing that's been adjourned, re-noticing is not required. This is what's stated in your rules, but that is under New York State law. That's what the principle of law is. However, we do have the discretion to require renoticing if there's a particularly long adjournment, like for example, if an application has been adjourned month to month to month to month to month. In those instances, it makes sense to renotice. Or there may be other reasons to renotice as well. There is a section of your rules that talk about sort of the order of operations. So prior to public comment on any application, the applicant presents a formal presentation describing the proposal. The chair would then identify all correspondence pertaining to the application received from the general public, enters that correspondence into the record. Any written materials received by the board at the meeting need to be entered into the record, and then copies given to the planning board members, either hard copies or email. And no action can be taken on an application that's subject to a public hearing until the public hearing is closed. Again, it's,
So just quickly
goes
on
without saying,
procedure, there, as far as written correspondence on an application by the public received prior to opening a public hearing. I'm assuming, and this is what we've done in the past, that those communications have been logged, saved, and then acknowledged as a part of the public record once the hearing is open.
yes, so all written communications sent to the planning board through ETHA. ETHA is the gatekeeper. Members of the public should not be sending communications directly to the planning board members. Everything gets sent to ETHA as the planning board secretary. All of those communications are part of the record.
Yep.
All get included as part of the record. They all get distributed to the planning board members and the board's consultants for review. I think what this is saying is that in your rules, and I can recall when Jay Shears was chair, he would have a list of all of the correspondence, and he would read through. We received a letter from so and so dated this, and I think that's what's referenced here.
Yep. And again, we've done that as well.
We have, yes,
And
yeah,
what I'm getting at is that it's usually the point in time when we open the public hearing
Yeah.
to actually physically enter those
right.
by acknowledging them.
That we've
on the
received,
record that
yeah.
we've received.
Yeah.
Okay.
Yep. Let's see, your procedures talk about procedures for motions, for voting. A majority of the whole membership of the planning board is required for a quorum and also to make a decision to grant or deny. So you have a 7-member board, you need 4 votes and 4 people to make a quorum. And that goes regardless of whether there's absences. So like, for example, tonight we have 2 board members not here, 5 board members here. The applicant still needs 4 votes to pass anything, not just a majority of the members present. Let's see, in the interest of time, I'm just skipping over some of the things that we've already covered in other comments. This is an important one. Guidelines for comment at a public hearing. This is item number 8. You have a list of rules that members of the public need to abide by as well when they're giving comments at public hearings. And that is that speakers have to step up to the podium to address the planning board. Before addressing the board, the speaker has to give their name and address That's really important for the record-keeping purposes so that EPA can log in the minutes the name and the address of the person speaking. Speakers shall address all members of the planning board and shall avoid speaking at any one member directly or to the applicant or to the general public present at the meeting. So all comments really should be directed at the board as a body, not at one particular member, and certainly there shouldn't be comments directed directly to the applicant or the public. The purpose of the public hearing obviously being for the board to receive comments for their consideration. It's not a sort of
Not intended as an exchange,
exactly,
either
not a
this way
dialogue.
or between individuals
Exactly.
and the public, right?
Speaker's time is limited to 5 minutes, and the chair can reduce that time to no less than 3 minutes in your discretion, and that can be modified at your discretion as well. But generally, an individual speaker's time shouldn't exceed 5 minutes. And speakers shall observe commonly accepted rules of courtesy, decorum, dignity, and good taste. Just be a decent person. Be polite, yes. Any statements made by the speaker shall not concern motives of a member of the planning board and shall not constitute a personal or political attack or criticism of any member of the planning board, any officer of the city, any consultant of the city, employee of the city, or the public. So again, be polite. No personal attacks.
I know we've had issues in years past, but people recently have been very well behaved.
I agree with that completely. And, and I think that is almost the exception these days. I was listening to a program by the New York State Bar Association this morning about handling public opposition and public comment. Specifically, it was related to school board meetings. And, over the past year or two, school board meetings in particular have just become,
Very emotional.
across the country, very emotional. So it's good to be reminded that in
Yeah.
places like Beacon, people know how to be polite.
Sometimes.
I think that at this board in particular, most speakers are very respectful, which is the 7th guideline for speakers, that the audience shall be respectful of all speakers and shall refrain from comments and gestures such as clapping, cheering, booing, private discussions, cell phone use, or otherwise interfering. Any speaker that fails to conform their conduct to these rules shall be directed by the chair to stop and yield the floor. But the applicant and the applicant's representatives are not bound by the time limits that we talked about before. The applicant can have more than 5 minutes to present their application.
6.
Yeah. You hear that, Taylor? I know we're short on time. There's a couple additional sections of the rules of procedure that are not earth-shattering, so I don't think we necessarily need to discuss them.
It's all good, and again, it's
But I think
available
we hit
for
the
all of us to
highlights.
peruse, and I'm sure none of this is new to us as a board, but again, good to just refresh.
Yeah,
Thank you, Jennifer.
you're welcome.